With my lord's permission. Not my apologies, my lord. I was under the impression that your lordships would be taking it up at 3:30 somehow.
No, we thought we'll take you by surprise. No, which are your cases?
Lord, 5901 of 2019.
How many cases?
Sorry.
How many cases you are arguing?
Two matters, my lord, I'll be making submissions on.
W-
Lord, since the records are common, my lord may just have the return.
No, just give us the number of the petition.
Lord, this is WP number 10310 of 2019. WP number 5110 of 2020.
5110 511
my lords.
0
My lords.
of
2020.
20. That's all.
My lords. There's one in which I have intervened, but the submissions are in these two matters. If my lords would think it proper, my lord, your lordships may refer to the return of 5901 of 2019, which was the matter probably Mr. Sanghi, my lords, submitted the
5901, like
Ashita Dubey.
You want us to see what?
Lords, I have my submissions, Lord. There will be, Lord, some incidental overlapping in the submissions with Mr. Sanghi, Lord. And some part, Lord, I'll pray. Your lordships bear with us, Lord. Some part would have to be read over again, Lord. There will be some overlapping.
No, Mr. Sanghi has basically read over those portions which said that this is this 50% reservation. I mean, it's not provided anywhere in the statute or in the constitution, but it's probably by creature of the judicial verdict. And that is based on the principle of equality. So, and also that in very rare circumstances that can be relaxed. Very rare. Which are also given some examples. Remote areas, tribal areas. And the other argument was that the Article 16 speaks of adequate or not proportionate representation. It was proportionate, then of course the population would have been the deciding factor already. Now, what else do you want to argue?
My respectful submission is brought. My lord may have the return of the state as to how the state intends to sustain this reservation, Lord. Then I'll try to meet out, Lord, all those aspects that the state has sought to raise to sustain this impugned enactment.
No, leave their return for them to argue.
No, Lord, I will have to meet what they are trying to say. That on that count, Lord, I want to refer to the return. Because my respectful submission is, Lord, from the return itself, it's a self-destructive stand which is taken by the state government, Lords. Probably, Lord, it was drafted at a time when Maratha reservation had not come. So they have taken a specific stand, Lord, which is totally destroyed by Maratha reservation.
That is proportionate representation.
And proportionate, Lord, even minus Maratha reservation, Lord, the legal position still stood as it was with Indra Sahni, followed by Lord Nagaraj and some subsequent judgments. My lord may have para 9 of the return. Lord, I'll try to summarize, my lord, what their stand is, and then I'll try to meet all those submissions, my lord, individually.
Para 9.
Para 9 of the return. No, it is in this spiral bound form, if your lordships would have. Page.
ये इसी में है 505. Yes.
But so after referring to various aspects of the judgments in Indra Sahni and others, they come out in para 9 to say
Yes.
May I read now?
Yes.
Therefore, in the light of the majority view as well as the concurring views expressed by their lordships in the case of Indra Sahni, the contention of the petitioners that under no circumstances the limit of 50% can be breached in case of grant of reservation has no legs to stand. It is further submitted that the constitutional bench of 9 judges in the case of Indra Sahni itself opened the windows and as such was kind enough to carve out certain exceptions under which the aforesaid rule of 50% was directed to be relaxed and the breach of the aforesaid rule was allowed. So this is the first stand, my lords, that Indra Sahni itself directs that there can be a breach of the rule with regard to 50%. Then my lords may skip over, my lord, and come to para 11. In para 11, my lords, they
No, this reply that you are reading is in WP 16552.
5901 of 2019.
Oh, this is in WP 16552 of 19.
My lord, the replies are essentially the same, but
Same.
probably, my lord, paragraphing may be slightly different.
यही वाला reply दो.
5901 is adopting the reply. Your lordships are right, my lord. It is in 16552 of 19.
Achha. All right. So that has been adopted. All
My
right.
lords.
Yes.
Lord, then their critical stand start, my lord, from para 11 onwards.
This is adopted in all petitions. State. Huh? This 16552 19. Reply has been adopted in all cases.
In my two petitions, my lord, it's the same return which has been adopted.
Yes.
Then, my lord, para 11 and 12 is where they seek to rely upon quantifiable data. Para 11 reads, my lord, it is further submitted that in addition to the law laid down in the case of Indra Sahni, the constitutional bench of the Honorable Supreme Court in the case of S.V. Joshi and others versus State of Karnataka and others reported in 2012 7 SCC 41. After considering the judgments of the constitutional bench of the Honorable Supreme Court in the case of M. Nagaraj and Ashok Kumar Thakur, and also in the light of the Constitution's 81st Amendment Act 2000 and the 93rd Amendment Act 2005 has held that the reservation exceeding 50% could be made if a quantifiable data is available with the government. Therefore, in view of the aforementioned pronouncements of law by various constitutional benches of the Honorable Supreme Court, it leaves no iota of doubt that in case extraordinary, exceptional, and compelling circumstances are in existence, supported by quantifiable data, then it is within the authority of the legislator to provide reservation in favor of the backward classes exceeding the limit of 50%.
No, what is this 81st and 93rd Amendment?
My lords, I'll just.
In which article?
No, those are in Article 1516.
1516. 81st and 93rd.
I just.
First.
But the 81st Amendment acts Article Clause 4B to Article 16.
81st Amendment brought in 16(4)(b),
My lords,
capital B.
16(4).
Well, that was for carry forward vacancies.
My lords, I'll just read it out, lords. Nothing in this article shall prevent the state from considering any unfulfilled vacancies of a year which are reserved for being filled up in that year in accordance with the provisions of
But this
reservation.
4B also talks about 50% ceiling limit
My lords,
at the end.
it says, my lord, filled up for determining the ceiling of 50% reservation on a total of the vacancies of that year. Not this rule of 50% has never been permitted to be breached, except in those very rare circumstances of which illustrations are laid down in para 810 of Indra Sahani.
No, this is 81st and 93rd is what?
Let's I just point out. Lord, 93rd Amendment brought in clause 5 to Article 15.
Mm. Mm. Yes.
With regard to admissions to educational institutions.
Yes. Mm.
So, my lords, paragraphs 11 and 12 of the return, the second stand of the state comes that they are trying to justify the enhancement of reservation based on quantifiable data to breach the limit of 50%.
Mm.
I'll try to point out, my lord, that quantifiable data is relevant for enhancement of reservation, provided it remains within the limit of 50%.
Mm.
But then quantifiable data cannot be used to breach the limit of 50%, and it will not fall within the category of exceptional circumstances, regardless of the population or the proportion of population that exists of a particular class with reference to the total population.
Alright, well, how do you explain this concept of quantifiable data?
Minutes, I'll bring those, I have those specific judgments. From Nagaraj onwards, as to what would be the parameters to test the quantifiable data.
Mm. Yes.
I'm just trying to take your lordships through, my lord, what the stand of the state is.
Mm.
Then my lords may come to para 16.
Yes.
Lords, in para 16 to 19, the state has relied upon the concept of proportionate representation to say that the OBC population is very high and therefore reservation in proportion to the population would be requiring a breach of the limit of 50%.
Mm.
I'll read, my lord, para 16.
Yes.
It is submitted that so far as scheduled castes are concerned, as per the census 2011, the total scheduled caste population was 11.3 million. In terms of proportion, the scheduled caste population constitutes 15.6% of the total population of the state. Similarly, the total scheduled tribes population in census 2011 is 15.3 million. In terms of proportion, the scheduled tribes population constitutes 21.1% of the total population. The answering respondents herewith mark an enclosed copy of the relevant part of the census of India 2011. It is further submitted that as against 15.6% of the total population in the
No,
state.
this is where? In India or in the state?
In India, my lords.
In MP?
In Madhya Pradesh.
In Madhya Pradesh.
In Madhya.
The scheduled caste population is
My lord, the scheduled
11.5.
caste population is 15.6%.
15.6.
And the scheduled tribe population is 21.1%. Now in para 17 they say as against this 15.6% of the total population of the state, the scheduled castes have been provided 16% reservation. So they are seeking to draw parallels, my lords. Whereas 21.1% of the total population, the scheduled tribes are being provided 20% reservation.
Mm.
It is submitted that census 2011 makes it evidently clear that the total population of the state of Madhya Pradesh is 7.26 crores. Backward class population in the state of Madhya Pradesh is 3.7 crores. And as such, the other backward classes in terms of the proportion constitute more than 51% of the total population of the state. Therefore, as per the census 2011, the scheduled caste, scheduled tribes and other backward classes in terms of proportion constitute more than 87% of the total population in the state of Madhya Pradesh. The answering respondent herewith mark enclosed copy of relevant document. Then 19. As mentioned in the foregoing para, that despite having 51% of their share in the population, the other backward classes are provided only 14% reservation, which is quite disproportionate vis-a-vis the quantum of their population in the state of Madhya Pradesh.
See, they are going in for proportionate
My lords.
reservation.
Yes, lords. That
So
has been their-
once this decision has come, how can you go in for proportionate representation? Yes. The proportionate representation they say it is adequate, not proportionate. Seems to be something wrong with your reply. It is running tangent to what the Supreme Court says. Now, why should we go into all this argument when the very first argument of proportionate representation has been struck down by the Supreme Court, criticized? But turn means another 2 days, 3 days. Why should we waste the time unnecessarily? Well, is that the only stand they have taken?
There is one more stand, my lord. They have relied upon a report which they say it's in fact that report is the bedrock of the submission.
Quantifiable data.
My lord, with regard to quantifiable data and other aspects that they say, the report has taken into consideration everything. That is their stand, my lord. I'll come to the report, my lords, immediately thereafter. They have a few more hurdles, my lords, to cross because that report is also a very self-destructive document, my lord, so far as the state is concerned.
All right. After lunch, we'll take it.
My lords, I'll come. So much.